and judgment in the matter of Annexter Limited and Secretary of State for Transport.
We have decided that Annexter's tenancy was a long tenancy which is about to expire for the purposes of the Compulsory Purchase General Vesting Declarations Act 1981, and that time for service of a counter notice under the Compulsory Purchase Act 1965 started to run when the notice to treat was delivered to Annexter. The reasons for our decision are contained in the judgments which I now hand down and which have been made available to the parties in draft. In consequence of our decision, the appeal is dismissed. The appellant shall pay the respondent's cost to be subject to a detailed assessment if not agreed. Permission to appeal to the Supreme Court is refused.
Part third appeal in the matter of the Financial Reporting Council Agency and Sports Direct International PLC.
Good morning, my lords, my lady. My lords, my lady, I'm going to start with ground one, and the starting point for that, we say, is Parry Jones. We submit that Parry Jones is a case about privilege. It is not just a case about confidence. We submit that, contrary to the suggestion by my Lord Justice Lewison yesterday, it is squarely a case about privilege. Lord Denning in Parry Jones thought it was, as did Lords Diplock and Salmon. All three judges in Taylor thought that it was, including Lord Justice Bingham, who had been counsel for the Law Society in Parry Jones. All five judges in Morgan Grenfell thought that it was, including Lord Hoffman, and all three judges in Sims thought that it was. So I turn then to the case itself to make that good. That's at Authorities 110.
Which tab?
10, my lord. Now, privilege lay at the heart of Mr. Parry Jones's case. We see that from at the top of page 5, in which, in person, he made his submissions are recorded. And his first submission at 5A to B is that Rule 11 of the Solicitor's Accounts Rules is ultra vires because it conflicts with Section 46(6) of the Solicitors Act 1957. That is a saving provision for a privilege, which I'll come to in a moment. If this were not so, it would mean that solicitors would in effect have no privilege. The Law Society cannot require a solicitor to produce information which, either by contractual obligation or because of privilege, he is not at liberty to produce. So that's the encapsulation of his first point. And if we turn to 46(6) of the Act as it was, we can see that is squarely about privilege. And that's at Authorities 1.1. Now, let me make that good. It does not mention the word privilege, but Lord Denning, in his judgment, refers to it as a provision about privilege. This is at internal page 4 of the bundle. For the purposes of any application or complaint made to the disciplinary committee under this Act, the committee or any division thereof may administer oaths, and the applicant or complainant, and any person with respect to whom the application or complaint is made, may issue writs of subpoena ad testificandum and duces tecum, but no person shall be compelled under any such writ to produce any document which he could not be compelled to produce on the trial of an action. Now, my lords, my lady, that is strikingly similar to the passage which I'll come to later in Schedule 1.8 of Schedule 2 of SATCAR, and I will rest further submissions on that similarity, but for the moment I'm making good only the proposition that at the heart of Mr Parry Jones' appeal was privilege, and the fact that the rules, Rule 11 of the Solicitor's Account rules, was ultra vires because it conflicted with that section. Now, returning to the parties' submissions, Mr Bingham, as he then was for the Law Society, then deals with the privilege argument, the first part of the submissions. That's the first paragraph we see. And then he deals with the confidence point, because the confidence point does arise in the second paragraph and the third paragraph. But in a sense, the submissions are secondary to those submissions are secondary to what the court actually then considers to be the foundation of the case, and they start with Mr Parry Jones' submissions. And Lord Denning makes the point at 5G following that Mr Parry Jones raised 2 points of some importance. And the second point was the natural justice point, which doesn't concern us here.
Sorry, which page is it?
I'm sorry, I'm so sorry, it's 6G at 166 internal. Mr Parry Jones raised 2 points of some importance, the second being the natural justice point. The first point is this: he says that he is not bound to produce to the accountant a document or information which is privileged from production. And so Lord Denning correctly understands, we say, the foundation of this part of Mr Parry Jones' argument to be privilege and not confidence. Now, it's also important to note in our submission that this part of Mr Parry Jones' argument is not just about books of account, it's about documents as well. That is consistent with the power under Rule 11 of the Solicitor's Accounts Rules, which includes a power to require documents to be produced. And we see that at the foot of internal page 162, page 2 of the judgment, of the report. And looking down towards the bottom of the first column of footnote 2, on a written complaint lodged with them by a third party, the Society may require any solicitor trustee to produce at a time and place to be fixed by the Council all books of account, etc. And documents is the final part of that, relating to all or any of the trusts which he's solicitor trustee. Now, it's that power to require production of those things which Mr Parry Jones is arguing is ultra vires. Now, my Lord Justice Lewison suggested yesterday in argument that the case was about books of account, which are not privileged, per the judgment of Lord Justice Blackburn in Nationwide. Now, accept that. But if that were the case, then the answer to Mr Parry Jones' privilege point would be that privilege has nothing to do with it. There'd be no need to go into privilege. But it's about much more than that. As we see repeatedly through the judgments, documents are at the heart of the issue here. Now, Lord Denning goes on in the next sections of his judgment to summarise the two types of privilege as he sees them, and then says that at 7b, in reliance on these principles, Mr. Parry-Jones says, that's the principles of privilege he's just enunciated, that the accountant sent by the Law Society should not be allowed to see documents or information relating to a client's affairs. Now, all this is dealing with Mr. Parry-Jones' ultra vires argument. Rule 11 is ultra vires, he says, because 46.6, which protects privileged documents from production, goes contrary to it. And in reliance on that, he's saying the Law Society's accountant shouldn't be able to see documents or information relating to a client's affairs. So Lord Denning then goes through section 29 of the Solicitors Act and Rule 11 made under it.
Just before we get there, on page 7 between C and D, Lord Denning seems to be saying there's an implied term of a contract between solicitor and client, but the solicitor must disclose his client affairs, if required to do so, by the rules. So he's saying, is he not, that the client has consented to the disclosure of this information by virtue of an implied term in the contract of retainer.
He's consented to his solicitor obeying the law, in effect.
Yes, and if that requires him to disclose his client's affairs, see the last sentence in the paragraph, then he, that is the solicitor, must do so. So that's on the basis of consent.
Yes,
as an implied term of the contract.
yes, my lord, and that would nowadays it would nowadays be seen more than that since Derby, but that is what he is saying there. I'm not sure how that engages the argument that I'm making, which is merely that this is a case about privilege. Lord Denning's route around that, in effect, is the override, which Lord Hoffman disparages. But the proposition I'm seeking to advance is just this at the moment, that this is a case squarely about privilege. Now, Lord Denning goes through section 29 and rule 11 made under it, and cites the passage that I've cited, or is in footnote 2, and says at the top of page 8, on a written complaint lodged with them by a party who may require any solicitor to produce his books and so forth, including, of course, documents. And he then says that the next section is his conclusion. He concludes Rule 11 is a valid rule. In other words, the reason he's using that term is that it's not ultra vires as a result of 46.6. Rule 11, he says,
Where are you reading from?
I'm reading at 8b.
So what he's saying is that the source of Rule 11 is Section 29 of the Solicitors Act, and that empowers them to make a rule which overrides privilege,
Yes.
and that Section 46 doesn't counteract that.
Exactly, my lady. And of course, Lord Hoffman later says that it's not a full. I'm going to use the term this morning, a full Morgan Grenfell statutory override, just to distinguish it from the technical breach issue, because our submission is that Lord Hoffman rejects the full Morgan Grenfell statutory override route. He finds that the next section of Lord Denning's judgment gives rise in effect to a technical override in very similar terms, But of course, in this sense, the law has moved on from this bit of Lord Denning's speech. There is no full Morgan Grenfell statutory override per Lord Hoffman's reasoning in Morgan Grenfell, which we'll obviously come to.
And by a full override, you mean one which is not conditional on absence of adverse effect for the holder and a duty of confidentiality on the part of the recipient?
Yes. In other words, one which is express or by necessary implication. I will return to per the Morgan Grenfell test, and Lord Hoffman finds that there is not a statutory override by express terms or by necessary implication in this. But he finds one alternative route, which is the non-infringement principle, and we say that the next section of his speech picks up exactly what Lord Denning says next, in the sense of a technical breach. So if I could just move.
Anyway, as I understand it, you're saying you're using the expression a full Morgan Grenfell override to be a statutory authorisation or requirement, doesn't matter, which is expressly stated or by it is necessarily implied.
Exactly, it's just a shorthand, my lord. I can use them.
That's fine, no, as long as I understand what it means.
That's exactly what I mean, because otherwise I have to repeat the whole mantra.
All right, that's fine.
So
what do you get out of this? The rule is a valid rule which overrides any privilege of confidence which otherwise might subsist between solicitor and client.
yes, but Lord Denning then goes on to say, but they and their accountant must, of course, themselves respect the obligation of confidence. They must not use it for any purpose except the investigation and any consequential proceedings. Now, I'll pause there for a moment, but that is very similar to the requirements for a technical override to exist, which we'll come to in Morgan Grenfell. What we say Lord Hoffman is doing is picking up this language of the confining of the situation to situations where you're obliged to keep it confidential and you can't use it for any purpose except the investigation. In other words, you can't use it adverse to, you can't use it against the solicitor's client. We say that what Lord Hoffman...
Don't those conditions simply arise from other provisions governing the Law Society?
What Lord Denning's reasoning isn't the same as Lord Hoffman's, as he makes clear. Lord Denning thinks there's a full Morgan Grenfell, he wouldn't have known that, but he thinks there's a full Morgan Grenfell statutory override here. And he justifies that in terms of, but it's going to be kept confidential and it's going to be used only for the purpose of the investigation. What we take from that is Lord Hoffman picks up that thread and says it doesn't justify a full Morgan Grenfell statutory override, but it does justify regarding the handing over of the documents or the requirement as a technical breach of the privilege. So this is the thread he picks up. The Denning justification for the full Morgan Grenfell statutory override is very similar to Lord Hoffman's justification for saying that there's only a technical breach of privilege. And that's the thread that runs through Taylor and into Morgan Grenfell. So there is a strong thread in relation to privilege that you pick up from Parry Jones and run through to the reasoning of Grenfell.
Well, I understand what you're saying, but this statement by Lord Denning at page 8c, which is the confidence point, is dealing with what happens once the documents have been handed over. So
Yes,
once you've handed them over, so there's there's a full override here, full Morgan Grenfell override, full statutory override, and he's dealing with the fact that, but don't worry, that's not the end of the matter, because when the Law Society get the documents, they can't do whatever they want with them. They are bound by the same confidence that the solicitor had in relation to them. So that's what that's dealing with. Now, my understanding is that Lord Hoffman, however, is not dealing with that second stage at all. He's dealing with the first stage. He's saying, well, there's no, first of all he says, well, there is no privilege attached in these particular circumstances. And
no, he's not saying that, my Lord. He's saying that there is the privilege attaches, but there's no infringement of it or only a technical breach of it. That's a critical distinction.
all right, we'll come to that. But the point I'm making at the moment, I don't want to get deflected from it. The point I'm making at the moment is he's dealing with the equivalent of the first stage being looked at here, which is the delivery to the Law Society. That's what Lord Hoffman's dealing with. And so, in a sense, there's a kind of a mismatch here, because you said, well, he picks this up, but he's looking at the first stage, and the first stage in Parry and Jones is there's a full statutory override.
Yes.
That's all I'm saying. It's
Yes,
not. They're not dealing with sort of similar things in a way.
No, and Lord Hoffman says that there is no full Morgan Grenfell statutory override. He thinks that Lord Denning's reasoning here is incorrect because the legislation and the rules made under it do not satisfy the test for express override or by necessary.
Well, in Morgan Grenfell's case or in Parry
In
Jones?
Morgan Grenfell's case and in Parry Jones' case. I'll come to Morgan Grenfell, obviously.
I mean, the only point I was seeking to make was they're not dealing actually on this point of confidence. They're not actually dealing with the same point.
My Lord, that is right. They're not dealing with the same point because what's happened here is that Lord Denning says there's an override, but don't worry, there's still the obligation of confidence. What Lord Hoffman does is he picks up there's still the obligation of confidence and only to use it for a specific purpose.
Yes.
And he says that means there's only a technical breach of the privilege in stage 2 of his reasoning. That's what he relies upon it for. And so we say that what he does is that there is an intermediate stage between no statutory override and a full Morgan Grenfell statutory override, and that's where there's only a technical breach. We draw attention only to the very close similarity between the justification for a full statutory override in Parry Jones and the justification that it's only a technical breach in Morgan Grenfell.
So let me make
If there is what you call a full Morgan Grenfell override, does that mean that the person or body to whom documents are produced are then free to do what they like with it? Is that the point?
Well, if
Whereas the Law Society was not.
no, but they'd be bound by the other provisions of the general law. If there'd been an override in Morgan Grenfell and HMRC had got the documents, then doubtless the law would deem that those were confidential for the purpose of the investigation. They can't just be used willy-nilly. And likewise, if the FRC...
So what is the intermediate stage?
Well, the intermediate stage between that is that the obligation of confidence will depend whether the override is a full statutory override or not.
Well, let's just go back to Morgan Grenfell for a moment.
Yes.
Say that had HMRC got the documents that they were asking for, they could only have used them for the purposes of their tax investigation.
That's right.
That is different from an intermediate stage, which is in Parry Jones, where the Law Society can only use the documents they get for the purposes of their investigation under the Solicitors Act. Now, what's the difference between the two?
It's the same model. There's not an intermediate stage. That's not an intermediate stage. The intermediate stage is saying that there's an intermediate between a full Morgan Grenfell statutory override and no statutory override. Whether your route to the override is full Morgan Grenfell or the Lord Hoffman route in Morgan Grenfell with.
I can't see the difference between full Morgan Grenfell and intermediate, as you explained it.
Well, I've obviously explained it inadequately, my lord. Perhaps it's best to go to law.
We mustn't take you out of your order.
I'm very happy.
Have you finished with Parry Jones? Is there anything further you want
Not quite, my lord. Just,
Why don't you finish on that?
yes,
and
my
then
lord.
we'll come to-
I assure you, I'm not going to duck Morgan Grenfell.
No, of course not.
We turn then, just to make good my...
Just to be sure that what you accept that what Lord Denning is saying in Parry Jones is that Section 29 of the Solicitors Act overrides privilege.
Yes.
That does not mean that it's a free-for-all, because there are other provisions of the law which restrict the ability of the Law Society to make use of that information.
Yes.
And one can say, knowing the knowledge of that may be what prompted Parliament to confer the override in statute.
Well, it didn't confer the override, as my lady, as found in Morgan Grenfell. It didn't confer it in statute because Lord Hoffman says that the rationale for Parry Jones is not that there's no LPP, and it's not that it's overridden. It is that the LPP exists, is not infringed, or that there's only a technical breach of it, given the fact that the documents of the information is to be kept confidential and not used against the person entitled to the privilege. So I see my lady's puzzlement, which always troubles. May I put it this way? My friends yesterday, my friend Mr Lesak yesterday said that the SRA currently has a full Morgan Grenfell statutory override. I will demonstrate in due course that in our submission that is wrong. The only route the SRA currently has is the Morgan Grenfell route. But if it were correct that the SRA had a full Morgan Grenfell statutory override, it would, that would be Lord Denning's position, which has been said to be wrong in Morgan Grenfell, and they would still have the obligation of confidence. I need to distinguish between two things. Whatever the route to the override, the regulator will still have an obligation of confidence. HMRC would still have an obligation of confidence. That obligation is pulled as a thread by Lord Hoffman into his rationale, which we'll come to, that there's only a technical breach.
Well, I think that's the point we've now got.
Yes.
That's when now we now understand. You're saying that's the piece he's picking up. It's not a totally analogous situation.
Yes.
But you're saying he's picking up the thought processes of Lord Denning and he's using it for the purposes of maintaining a technical breach. So I think we've got that point.
Exactly, Mark.
Yeah,
exactly.
we've got that.
So, does that answer my lady's point?
Well, let's see where we get to.
I don't think that's a yes.
I haven't taken it as one.
But let's move on.
Yes.
Let's
So,
go to James.
just finishing the proposition that Parry Jones is squarely about privilege. Lord Justice Diplock, if we turn to his... just going out of my course, I was taken away from one further point. So, Lord Denning says, in all other respects, and this is at 8D, the usual rules of legal professional privilege apply. See section 46(6) of the Act. So it is obvious, we say, that in his world of full Morgan Grenfell statutory override, Lord Denning doesn't think that 46(6) of the Solicitors Act, which we say is materially identical in its effect to 1/8 of SATCAR, but I'll return to that. He doesn't think that a saving provision for privilege stops this override.
But
And-
where was section 46?
46.6, my lady, it was tab 1 of the authorities bundle.
I think I've got a confession to make, Mr Simpson. I think yesterday there were several occasions when I was referring to you as Mr Lissack.
Yes,
I
did
apologise
notice
for that.
that.
I'm sorry, caught up in the excitement of the argument. I got confused.
Not
And
at
I
all.
apologise to both of you.
I'll take the credit if it goes his way.
Two Mr Littacks is more than any compliment.
Yes, I-
So, my lady, 1/6 we were looking at.
Right, so,
Can I take this in 2 stages?
well, so the rule that empowered the Law Society, the provision under which the Law Society made the rule saying they can call for documents was section 29(1)(c.
Yes.
That the rule was some action that they had taken that they thought necessary to enable them to ascertain whether or not the rules are being complied with.
Yes.
Right. And
So what?
similarly 29(2)(c) in this case as well, because Mr Parry Jones was asked both for solicitor and for trustee documents, right? And so the question was whether that enabled them to make a rule which overrode the privilege of Mr Parry Jones's clients, or whether it didn't,
yes, whether-
because of section 46(6)
Yes.
dealt with disciplinary committees.
It dealt with privilege in disciplinary
In
committees,
disciplinary
which is where it ultimately ends if you're
And
a
what
regulator.
Lord Denning thought he was deciding before he learned from Lord Hoffman what he was in fact deciding
Yes.
was that there was no such caveat on 29(1)(c, and that 29(1)(c) was not limited to only being able to call for documents that were not privileged documents.
No, and he thought that the saving provision, the important point for us later in my
Yeah, that had nothing to do with it.
that didn't stop it.
Stage.
So we say that's very similar to 1/8 of SATCAR.
Yeah.
It's
Right.
Lord Denning.
That's what Lord Denning thought he was deciding, that there was nothing in 29(1)(c) or 29(2)(c) which prevented the Law Society from making a rule calling for documents that were privileged.
I put it slightly differently, if I may, my lady, which
Yeah.
is that there was nothing in 46(6) which meant that the rules made under 29 were ultra vires.
No, but that's got to be a second.
Yes.
Consider-
Once he had decided that,
Yeah.
he decided that the rules, the statute and the rules, the combination, overrode the client's privilege. And Lord Justice Diplock, as he was, also, just to finish on this, also thinks that correctly that Mr. Harry Jones' argument's a privilege argument, because at 9b of the report, he says that the foundation of Mr. Parry Jones' case is the submission that an inspection of documents under Rule 11 of the Solicitor's Accounts Rules 1945 is in the nature of a judicial proceeding. Now, you don't extract that from Mr. Parry Jones' submissions as summarised in the report, but what Lord Diplock is saying is that must be the foundation of his case, because on Lord Diplock's interpretation of the law, which Lord Hoffman says in Morgan Grenfell is wrong, privilege is irrelevant when one is not concerned with judicial or quasi-judicial proceedings. I take this only, I don't rely on Lord Justice Diplock's judgment as authority for anything post Morgan Grenfell, but I do rely on it as showing that Lord Diplock as well thought that Parry Jones was a case about privilege, because he says the foundation of Mr Parry Jones' case is that it's in the nature that inspections under the nature of a judicial proceeding, and he says that because he thinks that privilege is irrelevant where you're not concerned with that sort of thing. On that interpretation, for Mr Parry Jones' argument to get off the ground, he has to say, on Lord Diplock's interpretation, that an inspection under Rule 11 is in the nature of a judicial or quasi-judicial proceedings, and that's because it's a privilege argument. And Lord Justice Salmon agrees with both judgments. The next case I want to deal with, my lady's Taylor. That's at 116 of the authorities bundle.
What tab is it?
116, my lady. Now, the first point to note, although it doesn't change the analysis, is that Lord Hoffman appears to have been wrong in Morgan Grenfell when he interpreted Taylor as finding that there was an override both of the solicitor's own LPP and of the client's LPP. There is no mention at all in Taylor of the solicitor's own LPP, i.e. the privilege and vice that he seeks from his own legal advisors. The head note is correct at 2 on page 409, when it refers only to the client's legal professional privilege, and that is picking up the passage later, the most important passage. This is obviously about section 20 of the Act, Taxes Management Act. We are of course dealing in Taylor with the same Act. It's 22 of the Act rather than 21, but we're dealing with the same Act as in Morgan Grenfell. And going to 413H,
H.
413H. On statutory interpretation, counsel for the applicant solicitor drew attention to the language of 20b2, so he draws attention to the language of the statute and says that Parliament could not have intended to override the client's ordinary right to legal professional privilege in respect of documents in the hands of a legal advisor. Now, my lords, I only draw it to your lordship's attention that this is all about the client's LPP, because Lord Hoffman does make a point later that Taylor's wrong on this, and he endorses it by a different route, by the same different route as in relation to Parry Jones, on the client's LPP point. So I mention that only in parentheses. So, looking at the client's LPP, Lord Bingham, Lord Justice Bingham, says he's unpersuaded by the argument. Lord Justice Bingham and the other judges, Lord Donaldson and Lord Justice Norris, think, as in Parry Jones, they think that there is a full Morgan Grenfell statutory override here. They employ identical reasoning to Parry Jones. And the nub of it is at 414A to B, having looked at the statute and the statutory provisions, Lord Justice Bingham says the clear inference is, in my judgment, that a client's ordinary right to legal professional privilege, binding in the ordinary way on a legal advisor, doesn't entitle such a legal advisor as taxpayer to refuse disclosure. So that when the legal advisor is being investigated by HMRC, they can't refuse disclosure of documents on grounds that that would infringe the client's LPP. And Lord Justice Bingham says that is not, to my mind, a surprising intention to attribute to Parliament. In different circumstances, the Court of Appeal has held the Law Society is entitled to override a client's right to legal professional privilege when investigating a solicitor's accounts. See Parry Jones. It is, I think, altogether appropriate that the revenue being charged with the duty of collecting the public revenue should enjoy a similar power. I accordingly agree with the Divisional Court. So, Lord Justice Bingham, who was counsel for the Law Society in Parry Jones, sees Parry Jones as a case on privilege, and he applies the reasoning in the context of the Taxes Management Act. And Lord Donaldson and Lord Justice Norris agree with him. Thus, all three judges interpreted Parry Jones as a case about privilege, and all three applied the Parry Jones reasoning in relation to the Solicitors Act to the Taxes Management Act. Now, my Lord, Lord Justice Lewison noted yesterday that the Divisional Court and Court of Appeal in Morgan Grenfell thought that Taylor was inconsistent with the outcome for which Morgan Grenfell were arguing. Now, the answer to that point is that in Morgan Grenfell, Lord Hoffman squared that circle with his no infringement technical breach reasoning. That's why they weren't inconsistent. So that's Taylor. I'll turn next to Morgan Grenfell.
You mentioned Sims.
I'll come to Sims. Sorry, did I mention Sims?
At the beginning.
I did. I'm going to come back to
You're
Sims.
going to come back to
I'm going to come back to Sims, yes.
You're going to Morgan Grenfell.
Morgan Grenfell, my lord, yes, 222. Authorities 2, tab 22. Paragraph 32, we canvassed this at length yesterday, so I'll turn straight to paragraph 32 at 612. Lord Hoffman looks at Parry Jones, he looks at Lord Diplock's speech, he says that's wrong in its reasoning, but he picks up the reasoning of the majority here. And he looks first of all at the outcome. He says, so he's looked at Derby, and he's said that privilege is a fundamental human right.
Where are you?
32,
32.
612, paragraph 32, my lord. I'm sorry if I missaid you.
We skipped over Derby then, haven't we? Right.
Well, we haven't skipped over it, my lord, in the sense that we take as read the principles in Derby,
right.
and we take as read the fact that Morgan Grenfell noted those principles, and we take as read the fact that he had them in mind when he he comes to this passage. There's no dispute on that.
So the consideration of Parry Jones starts at paragraph 26.
It does, my lord. Yes, of course, we can go to that. So what he's doing is explaining here why it is that there's a certain provision in the Taxes Management Act. It's somewhat Byzantine, but he's trying to look for an explanation which isn't Mr Brennan for the Revenue's explanation for this particular section. So he finds it in Parry Jones.
Yes, it's part and parcel of the exercise of construing the statute to see if there's an implied override of the
That's right, and he's working out why that passage is there, and he comes back and he comes to the answer, which he says is Parry Jones. So that's why
we'll never know whether Parliament, in fact, did go through that thought process when enacting the Taxes Management Act or not.
We will not, my lady, no. But Lord Hoffman certainly did, which is the point for these purposes. So he cites Parry Jones, and he goes through the reasoning, and he goes through Lord Denning's speech, Lord Justice Diplock's judgment, and then he observes that having already, my lord, referred to Derby, and he's coming back to the fundamental principle here, that the policy of LPP requires that the client should be secure in the knowledge that protected documents and information will not be disclosed at all. This is at 30. The reasoning in the Parry Jones case suggests that any statutory obligation to disclose documents will be construed as overriding the duty of confidence which constitutes the client's only protection. Now, he's picking that up, my lord, from Lord Justice Diplock's speech, which he's referred to in earlier paragraphs. But he's not saying that's all that Parry Jones decided.
Well, it's also the way Lord Denning dealt with it.
Well, my lord, no, with respect...
He said, look at the top of the quotation on top of the page. Lord Denning says there are two privileges. First is the privilege relating to legal proceedings, that's LPP. And the second is the confidence obligation. And Lord Denning, as I read him, thought that Mr Parry Jones was objecting on the basis of the confidence, and that's certainly what his injunction claimed.
Well, my lord, that is what his injunction claimed. It's right to say that his injunction mentions breach of confidence. But his argument doesn't. His argument proceeds on the basis that the rules are ultra vires. The rules requiring provision of documents or information are ultra vires, and they're ultra vires because of 46.6, which is a privilege provision.
I'm not sure why Lord Hoffman thinks that the reasoning in Parry Jones, Lord Denning's reasoning, suggests that any statutory obligation to disclose documents will be construed as overriding the duty of confidence. I mean, surely it must depend on the wording of the particular statute.
It must, my lady, and it's difficult to see that because he's interpreting it very, very widely, isn't he? But what matters for these purposes is he construes it as overriding the privilege of the client.
Yeah.
And so, in the next section, it says, in the present proceedings, however, it's accepted the client's protected by LPP and that this can be overridden only by primary legislation containing express words or necessary implication. He then draws attention to a New Zealand case in which the New Zealand judges pointed out that LPP wasn't merely a 1954 New Zealand case, obviously well prior to Parry Jones, was not merely a rule of evidence but a substantive right founded on an important public policy. So he's saying if attention had been drawn to that, they wouldn't have found that there was a full Morgan Grenfell statutory override. And so he has to find, and he does find, another explanation for Parry Jones. He says it's not to say that on its facts Parry Jones' case was wrongly decided. But I think the true justification for the decision was not that Mr Parry Jones' clients had no LPP, well clearly that's right, or, crucially, that their LPP had been overridden by the Law Society's rules, but the client's LPP wasn't being infringed. And this is where he picks up Lord Justice Lord Denning's, people's titles change so often I lose track, but he picks up the reasoning and he puts that into the reasoning here in relation to non-infringement, and says that they weren't entitled to use information disclosed by the solicitor for any purpose other than the investigation. Otherwise, the confidentiality of the clients had to be maintained. In my opinion, this limited disclosure did not breach the client's LPP. So he is seeing the rationale, he is seeing Parry Jones as being, having to be explained in terms of no breach of LPP, not just in terms of Parry Jones being about confidence. He says, in my opinion, this limited disclosure did not breach the client's LPP, or to the extent that it technically did, was authorised by the Law Society's statutory powers. Now, in other words, there is something short of a full Morgan Grenfell statutory override,
Why was there no breach?
might I come to that a bit later? I'm going to take on the point of principle as to why we say Lord Hoffman's reasoning is cogent and correct a bit later, if I may, but I will return to that point.
This is what I don't understand, because it's accepted. I don't understand this analysis, because in the case it was accepted that if the client had LPP, it could only be overridden by primary legislation containing express words or necessary implication. That was accepted. And when he says, okay, there was a technical breach, he's accepting on that hypothesis that there was LPP.
Yes.
So it seems to me that there's an unexplained, at the moment, an unexplained mishmash between what is said at the end of 30, which is if there is any LPP, it can only be overridden by express word or necessary implication, and then what he says in your interpretation of it later on. That's what I don't understand.
Well,
I mean, otherwise he should be saying in the 30, it's accepted the time to protected by LPP. This can only, full stop, this can only be overridden by primary legislation containing the express or necessary unless it's a technical breach.
Yes.
Which he doesn't say.
That's obviously we're attempting to construe his speech. He doesn't say that, but it is obviously implicit in what he says later that is what he is saying, unless he says there's no infringement because of these particular conditions being fulfilled, or there's only a technical breach. So what you get is the full Morgan Grenfell statutory override, and perhaps you expect to come to this and say, well, of course, Parry Jones is overruled because there isn't enough. There isn't a full Morgan Grenfell statutory override in Parry Jones, but he doesn't say that. He says that there are two routes to the Parry Jones outcome, one of which, the technical breach route, picks up Lord Denning's reasoning on confidence and limited use. So what he is saying, there is a third way, as my friend Mr Lissack put it yesterday. Mr Lissack says there can be no third way. You've either got the Derby privilege, and it can only be overridden by express words or necessary implication, and it isn't. Or you haven't. But he finds a way through that thicket in the context of regulatory proceedings, we say, by this reasoning, which is, and I will return, I'm merely canvassing the cases at the moment, but I'm not going to duck why his reasoning is correct in principle. But his reasoning is two routes to the same end. Either there's no infringement because of the limited use and the confidence, or there is only a technical breach. Now, and he applies the same reasoning when he comes on to consider Taylor, but I can deal with the justification for that in principle now, but I prefer, if I may, to finish the tour of the cases and return to that in a moment. Now, one of the main points put against the FRC's position, it's worth going to the Taylor point as well, just because we've been to Taylor. And at 36, he deals with Taylor. It may be worth refreshing memories on that. I won't read it. But the reasoning is identical. Now, it's beyond doubt, we say, given the conclusion that Lord Hoffman reached on the substantive argument put forward by Morgan Grenfell, rejecting the argument that 20 of the TMA overrode LPP by necessary implication, that Lord Hoffman didn't think Taylor could be explained as a conventional Morgan Grenfell statutory override case. But he still agreed both with the result and with the reasoning, which meant that the solicitor was not entitled to withhold client privilege documents on grounds of LPP. His route to that was the non-infringement point and the technical breach point. Now, it's worth noting that
So he's saying that you can explain the decision in Taylor on the same basis as he's explained the decision in Parry Jones.
yes. He squares the circle that the Divisional Court and the Court of Appeal couldn't square. Now, at the heart of Sports Direct's submissions is the fact that this reasoning is not reconcilable with Derby magistrates or the cases, the numerous cases subsequently which have applied the Derby magistrates' principles. Now, it may be a forensic point rather than a substantive point, but it's clear that Lord Hoffman thought it was reconcilable, and as did all the other judges. And Derby wasn't a case that went under the radar in Morgan Grenfell. It was smack at the heart of it. And in none of the many cases since in which Morgan, and they're in the bundles, and number doesn't add to weight going through numerous cases, but in none of the cases since in which Morgan Grenfell's been considered has any judge suggested, I'm not saying it's not suggestible, but has any judge suggested that Lord Hoffman's dicta are not reconcilable with the fundamental principles of LPP. This is the first.
So where are you referring to now?
I'm doing a tour d'horizon of the numerous cases which are in the bundle.
Can we just look at Lord Hobhouse's analysis?
Yes.
Does not follow that of Lord Hoffman. He says, at paragraph 45, this was the passage to which Mr Justice refers to, that there's only one issue, is if the statute does not contain any express words to abrogate the common law right, the question, and that's the only question he poses, is there a necessary implication to that effect? And he explains what that is. Now, all the other members of the appellate committee agree with both judgments, but more to the point, they agree with the reasons which Lord Hoffman advanced for dismissing the appeal. And I take that to mean the essential reasons, which is the ratio.
Well, my lord, at 42, Lord Hobhouse does say that he agrees with the opinion of my noble and learned friend, and that opinion is the speech.
Well, 43, this is not 43, he says 40 is a question of statutory construction, and he says there's no balancing exercise, and then he deals with the question of statutory construction in 44.
Yes, my lord.
And then 45, he says that's the question.
Yes, my lord.
I'm just trying to see what status attaches to Lord Hoffman's dictum in this sense.
Well, I'm not sure it's going to get me far to parse what he says in 42, my lord, but in 43 following, he's looking at the full Morgan Grenfell statutory override reasoning. His reasoning is entirely consistent with Lord Hoffman's reasoning on that point. In relation to Parry Jones, then when he says simply, my reasons for agreeing with the opinion of my noble and learned friend Lord Hoffman, my lord, if I lose one judge, so be it. But the fact is that Lord Hobhouse is looking in a particular passage, which I'm going to come back to when I come to B, at the full statutory override point. If he disagreed with Lord Hoffman, then he would surely say so on such an important point in relation to Parry Jones.
Well, except he deals with in the middle of 46, isn't he dealing with the same problem that Lord Hoffman was dealing with, which is when you're considering whether you should imply into the Taxes Management Act an override for LPP in these circumstances, what do you make of the provision that confers LPP expressly on the documents in the hands of the lawyers and the barristers? Does that point against or in favour of a wider override? And he says, he asks the question, why preserve LPP in respect of documents in the hand of the advisor when the client has not consented to waive the privilege? But he doesn't go into the rather tortuous argument that Lord Hoffman comes up with. He just sort of leaves the question there.
Well, I'll come on later to the argument that Lord Hoffman comes up with, and we say it's not tortuous, that it is rational, particularly in the context of regulation, that interpretation should be arrived at. One has to remember behind all this, policy reasons will lie, and regulators, I'll come back to this point, particularly the SRA, couldn't do its job properly unless it could get client privilege documents.
And the essential distinction between Morgan Grenfell and Taylor, as interpreted in Morgan Grenfell, was that Taylor was concerned with clients' LPP, and Morgan Grenfell was concerned with Morgan Grenfell's own LPP. Is that right?
Taylor was certainly concerned with client LPP, as was Parry Jones. Morgan Grenfell was concerned with client LPP. Can they get hold? Can the revenue get hold of documents under 21 of the TMA and do the statutory provisions override that privilege? So the question is
But what they wanted was the advice that Morgan
I'm so
Grenfell
sorry.
had
No, it's
themselves had received.
it's they themselves
in
have received.
formulating
Yes.
their tax avoidance
Yes.
scheme.
So there's no override of that. I'm sorry, I've misled you. Lord Hobhouse, in his speech, is dealing squarely with the full Morgan Grenfell statutory override point. Now, if he had,
As I said, I was having difficulty with this
Yes,
position. So
yes,
the full Morgan Grenfell override, as you called it, would mean that the target of the inquiry cannot rely on his own LPP to resist disclosure.
yes.
The intermediate position, is this right, is that the target can rely on his own LPP, but can't rely on a third party's.
Yes.
Is that
Yes.
have I got that
Yes, and in Taylor and Parry Jones, it's beyond question that the absent express statutory override, if there is an express statutory inroad, and there are some into LPP, then that can be overridden. I'll come to some examples of that later. I'll come to some examples of why you can't give an assurance as unqualified as can be read from Derby. But what we are concerned about here, crucially, is client LPP, and we're concerned about it obviously because
I'm just trying to follow this one through.
yes,
So, in our case, Grant Thornton could rely on its own
Yes.
LPP to resist production to the FRC.
yes, because that will be
Grant
use adverse.
Thornton
I'm so
could
sorry.
not rely on Sports Direct LPP
No.
because you say there is this intermediate position. And if Grant Thornton can't rely on SDI's LPP, nor can SDI, even though it's their own LPP.
It elides into the same question, which is an override. It elides into the same question, which is it overridden by a Morgan Grenfell full statutory override, or is it not infringed, or is there a technical breach? And the Morgan Grenfell route is it's not infringed, or there's a technical breach.
It's curious state of affairs, though, that somebody else's LPP is overridden
Well,
when your own is not. You might have thought that the legal advisor was under an even greater duty to preserve somebody else's LPP than his own.
well, a legal advisor is under a duty to claim, to assert LPP on behalf of a client if asked to give up the client's documents. There's no doubt about that.
After all, the lawyer can waive his own LPP, he can't waive his client's.
Yes, you can. But in the sense of there are two categories here, and GT is a good example. GT's own advice can't be got because that would be use adverse to, and there's no
What do you
full.
mean GT's own advice?
The
The advice
GT
they
I
gave.
was being less clear. I'm
Well,
so
they-
sorry, my lady. The advice to GT from their own legal advisors cannot be obtained under SATCAR
Why not?
because SDI, so because the FRC is acting in essence potentially adverse to GT because it has the power to discipline them for
So
breach
what?
of
Why
the
does that make any difference?
well,
This whole thing is going to be adverse to Grant Thornton, presumably.
of course, my lady, but let's take the solicitor's example.
Well,
when-
I mean,
All right.
I can understand the logic in making that distinction. What I can't see at the moment is where is any provision that draws a distinction between either in the notice. Did the notice make it clear that they were not asking for those documents? or-
Yes. I mean, the notice does not seek privileged documents. Does not seek privileged documents in the hands of GT in the sense of that they are advice from GT's own legal advisors.
It's not covered by the notice.
No,
But what is it that stops them from asking for that then?
what stops them is that they don't have a statutory power, a Morgan Grenfell full override power to do so, and they don't fall within Lord Hoffman's exceptions because this is very important, because the FRC they can be used against GT. So if GT's own legal advice in relation to the audit were obtained and usable by the FRC, that would be an infringement on Lord Hoffman's reasoning of their LPP because they're documents, there's information that can be used against GT. Now let me might I give the example of a solicitor? So the SRA, pursuant to the Morgan Grenfell principles articulated by Lord Hoffman can get in an investigation, when it goes into a solicitor's offices, it can get documents which are privileged vis-a-vis the clients of the solicitor, that the advice that the solicitor has given the client. What it cannot do is get hold of the solicitor's own legal advice, and of course, and the distinction is that in the context where you're seeking third-party documents, you're not potentially using, this comes to the adverse use exception, you're not potentially using those third-party documents against the third party. But when you're seeking the person's own legally privileged advice, I'll come on to this when we come to B, then you are potentially, as a regulator, using it adverse to that person. So it doesn't fall within either of Lord Hoffman's exceptions, and it doesn't fall within either, because crucial to both is the idea that you're not going to use the documents against them. So in this case, the FRC will come on to the arguments on what adverse use is later, but the FRC has subject to the corporate reporting arm, and we're talking at the moment, and I'll come back to that, about the enforcement arm. The FRC does not have the power within the audit scheme or the accounting scheme to discipline Sports Direct, and therefore, as part of its work, as part of its establishing the factual basis of any complaint, then it is entitled to see, we say, the privileged advice, which is privileged in the hands of the public interest entity, because it will not use, the enforcement division of the FRC will not use that, cannot use that against the public interest entity. And that's the rationale in relation to solicitors as well. When you go in as the SRA to a solicitor's practice, you can ask to see all their files, because there's no infringement of the client privilege, and because it's only a technical breach of the client privilege, because you're not going to be using that information against the client.
And you'll come back to why it's not a breach at all.
I will, my lord. I won't be allowed not to. But it's not a breach, or it's a technical breach of their LPP, because the documents are going to be kept confidential for the purpose of a Law Society investigation, SRA investigation now, and they're not going to be used against that ultimate client. But what you can't do as the SRA, and everyone accepts this, the FRC accepts it can't get, the privileged legal advice of the legal advisor to the subject of the investigation. That's why the adverse use point is so important. So the current route, and I'll come back to this, the current route by which the SRA obtains or is able to see client documents is Morgan Grenfell. There is no express or implied statutory override in the Solicitors Act of client LPP. So obviously when the SRA goes in to try to investigate a solicitor or a complaint, they have to be able to see client files. Otherwise they can't investigate. Their job could not be done properly without that ability.
Well, why isn't that a basis for implying an override?
Could I take, because, my lady, it is not enough per Lord Hobhouse in Morgan Grenfell to say, in effect, it will be a reasonable implication into the statute to do that. It has to be a necessary implication. But I'm going to go.
That's the problem you've got. As soon as you say there is LPP, somewhere or other, you have to find an express provision or necessary implication. Now, it could be that on analysis, what Lord Hoffman is saying is, and that would be consistent actually with what was put earlier on about can only be overridden by express or necessary implication. Is you can say, well, in the case of an infringement of legal professional privilege which carries these characteristics, namely, it can only be used for a specific purpose and can't be used for other purposes, and so on. That in those circumstances, you're to read, the proper interpretation of a statutory provision for the disclosure of books to a regulator, that is to be read as expressly or by necessary implication authorising that particular type of incursion. That would be at least consistent with the overall analysis.
Well, my Lord Hoffman didn't think that.
Well, I don't know, because he doesn't go on to explain it. He simply, what he says is, though that particular, well, he talks of a technical breach, but that particular type of breach which he's defined, and he's defined it by reference also to Parry Jones, he's saying, well, that is authorised by the statutory obligation, or regulatory obligation backed by statute, to disclose the books and documents. Well, that's a matter of statutory interpretation. So that must be on the basis, either it's express or necessary implication. That's the only two ways you can interpret a statute. There's no other way of interpreting a statute. It means what it means.
I understand that, Lord.
You know.
Of course.
I mean, otherwise, what is the test for statutory interpretation? Is this some kind of new species of statutory interpretation?
Well, my Lord, the reasoning of Lord Hoffman is right in the middle of a case which makes all these points. It is the Fonse Origo of this doctrine.
Yes, it's still a matter of the point I'm trying to make. I'm sorry, perhaps I'm making myself clear. The point I'm trying to make is, even on Lord Hoffman's way of analysing Parry Jones, it's still a question at the end of the day of statutory interpretation.
Well,
because he's saying, to the extent that it technically did, it was authorised by the Law Society's statutory powers. So that's a question of statutory interpretation.
yes, my Lord, I accept that.
So all I'm trying to say is, well, what's the test? Now, you could argue, I suppose, by way of to produce a consistency by saying, well, what Lord Hoffman's to be treated as saying is, where there's an express obligation on the part of the target person, or an express right on the part of the regulator, at least in the case of the Law Society rules, to require the production of documents, that will, on either he's saying that the correct interpretation of that is to authorise this particular type of infringement of LPP. Otherwise, what is the? I mean, what I don't understand. What is the statutory test?
That's what he's saying, my Lord. It is to authorise this type of infringement, that being a technical infringement. But I do take your Lordship's point that, as a matter of logic, it's a matter of statutory interpretation for his second route of technical breach. It must be, because if it's authorised, if it's a technical breach which is authorised by the Law Society's statutory powers, then he must have some view on what those powers are. And he does from Parry Jones, and of course they've been continued into the SRA in roughly the same terms. There's the same privilege saving, for instance, and I'll come to that.
I think he has to say that is an express authorisation. That's what he has to say, because you construe, when you're talking about expressly authorised, it doesn't mean to say the words literally say that. It's on their proper interpretation. What do they provide? Or a necessary implication. That's the other way of doing it. There's only two ways that you can interpret statute. There's no other way of doing it. So he must be saying that on the proper interpretation of those statutory powers,
Yes.
they expressly or by necessary implication authorise an infringement of this particular degree
Yes.
of LPP. I mean, I can't see any other way of looking at it.
Yes, he must be saying that, and I come back to my Lord Justice Lewison's question to me on technical breach, which in essence I suspect will be what's a technical breach, and
Well, I asked you, why is there no breach?
why is there no breach?
Yes.
Sorry, I'll come back to that one, but if I can take this one in all as we're on it. So he does that by if it was said pejoratively, it could be said against me, inventing the concept of technical breach. But he does it via the concept of technical breach. And his reasoning is that if it's only a technical breach, then powers of the type given to the Law Society authorise it. But of course, my Lord, your Lordship is quite right that that is, by definition, an exercise in statutory interpretation.
Right, but statutory interpretation has no role to play in the first no infringement.
No, it doesn't.
Because if there's no infringement of the privilege in these particular circumstances, you don't have to worry about any express or implied authorisation because there's no infringement that needs to be authorised.
No, he uses the same route, the confidential, not to be used against route.
But that's the inventing bit in a non-pejorative sense.
In a non-pejorative sense, it has a certain novelty to it.
It may stem from the reasoning in Harry Jones that this was an implied term of the contract between the client and the solicitor, and if the solicitor was required by his regulator to disclose information, he would be at liberty to do so. And therefore there is consent.
It may, my
It
lord.
seems to me to be the only intellectually respectable way of justifying the no infringement point.
Well, certainly that is an intellectually respectable way of justifying it, my lord.
What are the other ones?
Well, what will now be, I'm sure, the disreputable way that I'm about to come to, but it is a way of justifying no infringement, that the implied term route is a way of justifying the no infringement point.
So, can I get back to, before we get to the no infringement point, I'm still on the technical breach point. So, I don't know that you've actually put it this way, but you may have done, and I may have overlooked it. That your second string, either you say, well, there's no infringement on the terms of your regulations that you bind you, or you have to say, by way of analogy with Parry, as interpreted by Lord Hoffman, and you say agreed by everybody else, the rules that you abide by as a regulator are to be interpreted as the rules are to be interpreted as being authorised. I'm putting it wrong. Sorry. The statutory provisions under which those rules are made are to be treated as authorising, expressly or by necessary implication, the type of disclosure that you want.
Yes, via either the non-infringement route or the technical breach route.
If it's non-infringement, you don't need this point.
No, well,
I'm talking about if you're wrong on the non-infringement point.
yes,
And Lord Hobbie don't accept Lord Hoffman's interpretation of that.
yes,
You're then cast back on a question of statutory. So that's what I'm trying to get back to. I'm trying to make it more conventional, fitting into the ordinary jurisprudence of this country.
yes.
And so we're coming back to the question of statutory interpretation.
Yes.
The question is, does the statute, directly or indirectly through regulations, in your case, authorise this particular degree of infringement because you satisfy the various qualifications in paragraph 32 of Hoffman, and his analysis was that in those circumstances that's what was authorised in Parry Jones by the statutory provisions which govern that, and you're in the same position.
Yes.
But then you have to start off with what does the statute authorise?
Yes.
Well, I don't think you quite cast it like that, but that would be a much more conventional approach.
Well, talk about expressly or by necessary implication,
Yes.
it's obvious from Lord Hoffman's reason that a lesser, it's really necessary implication, because if it's express, we don't have a problem. So we're talking about necessary.
Express as interpreted. I mean, as I said,
Well, it could be, my lord.
it could be an express provision because you're bound to disclose these things. It could be.
I
But
see.
it could be either. It doesn't really matter.
Can I deal with necessary implication? The threshold of necessity is lower where there's a technical breach. That's what Lord Hoffman is saying, my lord, and because otherwise you're into the. Well, if that doesn't
But
run,
in order to decide whether it is the case that the regulator is bound by a duty of confidentiality, is bound not to use the material adversely to the target, how do you establish whether those conditions are made out either in respect of any particular regulator or in respect of any particular target? I mean, if the statute said the FRC is entitled to use any material that it receives in response to a Section 2 notice to trigger or in the course of any other investigation that it is carrying out at the time, then the rules would have made it clear that the condition is not satisfied, that it's bound by confidentiality. So then you wouldn't be able to take advantage of the no infringement.
so I'm not quite sure I understood the analogy.
Right. You accept, I think, that the no infringement route, the first route that Lord Hoffman envisages, is dependent upon the regulator being bound, first, not to disclose it to anybody else, and B, not to use it adversely against the target who has handed it the information.
I would say bound by a duty of confidence.
Yes, bound by a duty of confidence. Suppose, however, that the rules contained a provision that said if during the course of its investigation into an auditor, the FRC uncovers wrongdoing by another professional person, it may disclose that information to the relevant regulator, and thereby showing that actually you weren't bound by a duty of confidentiality, you were empowered by the rules to disclose the information to somebody else.
Well, there's no dispute that the rules under which the FRC operates have some statutory gateways whereby they can disclose.
Right.
But to people and entities bound by the same duty of confidence.
Yes, well, you can tell a secret to 100 people. It's still a secret then if they all say they're going to keep it secret.
Yes, my lady, but then you come into this. It's right to say, and we're going to look a bit later at the way that the FRC can use SACCAR documents, the statutory gateway whereby it can use SACCAR documents in the accounting scheme a bit later. But you might say, if there were a separate regulator of accountants, and indeed a lot of the regulation of accountants is done by the individual professional bodies, that disclosure to that regulator would not be a breach of the duty of confidence. So it's a duty of confidence within a certain sphere, but the fundamental basis of the Hoffman doctrine, both for non-infringement and for technical breach is one, that you do have this duty of confidence, but two, and very importantly, that it's not being used and I'll come to this later. It's not being used adverse to the person. Now, returning, if I may, to my Lord Master Roll's point on technical breach.
Yes. I mean, are you saying, what you seem to be saying is that in this particular factual situation, the normal rules of statutory interpretation don't apply, and that where there's no express provision, you can still get to the same end because it's something less than necessary implication. What is it? Is it a reasonable implication? What is the test?
Well, Lord Hoffman doesn't tell us.
I'm asking you.
I accept that, my Lord. But a reasonable implication, at some threshold lower, the apogee of the high point of express words on necessary implication is Lord Hobhouse in Morgan Grenfell. But it has to be something lesser than that, otherwise it couldn't occur. I know that reasoning is circular,
But this is quite important, because if we in this court uphold this particular argument of yours, which is something other than ordinary express provision as interpreted, as construed, or necessary implication, then we have to tell everybody what the test is. We can't say it's something less. We've got to tell people what it is, so the court can apply it.
well,
So we need to know what it is.
well, we would say that it is implicit in Lord Hoffman's speech that a reasonable implication is enough, because otherwise he can't get there, as your Lordship said. And
Right. Can you just help me on this then? Sorry to press you on this, because
No, it's all right.
for the reasons I've mentioned, it's actually quite important in terms of other cases. Is there any other? That's my Lord Justice Lewison knows as much about this as anybody else. But is there any other area of the law where it's recognised to be a legitimate canon of statutory interpretation to say a reasonable implication is sufficient?
not that's a big question, my Lord, but not so far as I'm aware. But we'll have a look at that.
That's again quite an
Yeah.
important point, because if we're
Yes.
creating a new, if and I don't know what the answer is, but if we are creating a new canon of statutory interpretation, we need to make that really clear.
Of course, I understand that, my Lord. But
You're right, Lord Hoffman doesn't specify. That's why I was putting to you.
yes,
That's why I was putting to you that he must be saying that it is expressly or by necessary implication a result of those particular statutory powers in the Law Society that were in issue in Parry Jones, which led to the conclusion that this degree of infringement or reduction of the LPP was permissible.
yes,
You'd also have to factor in that the reasonable inference, actually clear inference test, was the reasoning of Lord Justice Bingham in Taylor, pages 413 to 414, and that's expressly disagreed by Lord Hoffman in paragraph 36.
yes, and so one is left with a puzzle.
But isn't the puzzle resolved by Lord Millett in B and Auckland, where he says quite clearly what a useful test is, paragraph 59. A useful test is to write in the words not being privileged documents into the power to call for documents, and ask not does that produce a reasonable result, but does that produce an inconsistency, or does it stultify the statutory purpose?
Yes,
I mean, do you accept that that is the test?
yes, but I don't accept that B has anything to do with this, because it's not a case about client LPP. It's a case about the LPP of the firm, and I'll make that good by reference to it, because it's an important point if I may come to that.
Anyway, so I'm going to recall you're saying it's sufficient if there's a reasonable implication
In this context.
in this context. In the context of the so-called technical breach.
Yes, well,
Yes, thank you. But it would be helpful if, because you obviously won't finish before lunchtime, it would be helpful if you or your junior could just see if there's any other area of statutory interpretation or the law where such a test has been used.
will.
Thank you.
So, turning, if I may, to B, the Sports Direct placed heavy reliance on this. And their submission was, in essence, that 3 of the 5 judges in Morgan Grenfell, sitting on this case, held that similar provisions in the New Zealand Act, Solicitors Act, Law Practitioners Act, did not override the client's LPP. And so what Mr Lissac said was that those 3 judges, at least, who sat in Morgan Grenfell, must have thought there was no third way per Lord Hoffman. They must have repented, in essence. Now, it's right to say that B in Auckland was nothing to do with override of the client's LPP. It's right to say that in paragraph 12, it is said that the documents were handed over to Mr. Enner, who was counsel assisting the Complaints Committee of the Law Society. And it's common ground that they were all covered by LPP, and what is said is that in some cases the privilege was that of the firm itself or its partners, in others it was that of the clients. Now we go next to paragraph 18, because what was in issue in B was the documents which had ultimately been requisitioned out of that pool by the Law Society of New Zealand. And at 18 we learn that the Society refused to return documents and serve formal notices under 10.101.3 of the Act, 1, requisitioning some of the documents already in its possession, and the other requisitioning further documents to which LPP also attached. Now the question is, what were those documents? Were they only documents privileged to the firm, in other words, their own legal advice and its members, or were they documents also, as 12 implies, with the original pool, were they documents that were client LPP, covered by client LPP? Now the answer to that isn't, I'm indebted to Ms Loveridge for this point, but the answer to that is not in the speeches, it's in the submissions of Job Consumption QC for the applicants. And at 396, I'm so sorry, it's, I proceeded on the basis you've all got it, it's 224 is the a reference in the authorities bundle.
Sorry, where are we in the authority?
We're on page 396. We're page 739. I'll use the.
Yes.
Yes. So
This is Mr. Sumption.
this is Mr. Sumption, and he says it's common ground that the requisition documents. This is at 739B. Are A, relevant, B, privileged, and C, that such privilege is based on the firm's or its members' own LPP. And so everyone, including the Divisional Court in Sims, have been misreading this on the basis of paragraph 12, which refers to client privilege documents. But in fact, it's a case all about the firm's privileged documents. And that makes a lot clear because consistent with that, in argument, the Law Society only sought to rely on a full Morgan Grenfell statutory override or waiver. Now, the Law Society did not seek to rely on Lord Hoffman's dicta in Morgan Grenfell in relation to client privilege documents for the obvious reason that they weren't in issue. If they had been in issue, it would have been very surprising that the Law Society didn't rely on the Hoffman-Morgan Grenfell exceptions in relation to those documents. And it also explains the fact that although there is no mention at all of client waiver, there is mention of the documents being handed over by the firm, but the firm obviously wouldn't have the power to waive on behalf of the client. So the jigsaw comes together. You can see why and how B was decided as it was. It has nothing to do with this case because it's about documents that were the firm's privileged documents and its members' privileged documents. So it can't be taken as undermining in the way that my friend suggested it did the reasoning in Morgan Grenfell, or suggesting that 3 of the judges had repented of Morgan Grenfell. Indeed, rather than supporting Sports Direct's argument, it undermines it. And that we have to remember, of course, that Morgan Grenfell was only a year before. Rather than supporting Sports Direct's argument, B undermines it because Sports Direct have asserted for the first time yesterday that in this country there's an implied statutory override in relation to investigations by the SRA of solicitors, albeit they haven't identified the section of the Act which they rely on. Now, there's no hint of that anywhere in their skeletons, and their ground 1 is simply that any false production of a person's privilege material, even to a regulator, constitutes an infringement of that person's privilege. But the reason we apprehend that they're now saying that there is an implied statutory override of LPP, and that must be, on their case, must be the Morgan Grenfell full statutory override, is that they realise the enormous implications if there is no ability of the SRA to obtain documents. And they're saying to you, well, it's okay, you can say the FRC can't get it because Morgan Grenfell doesn't hang together and it doesn't fit with Derby, but don't worry, because the SRA will still be able to do its job. But it won't be able to do its job properly because there is no statutory override. No one has suggested that there is, except one person in Sims, and the Sims case was argued on the basis of B, and even then, and even understanding, as they did, that B was about client LPP, the divisional court rejected it. So, indeed, the basis of Sports Direct's necessary implication Morgan Grenfell argument is the fact that the SRA couldn't do its job properly without, which is obviously right, without getting hold of client documents. Now, the only route is Morgan Grenfell for the SRA, and if it were otherwise, then Lord Hoffman would sit...
Why do it so... okay, I'm running a bit behind you now.
I'm so sorry.
Why, that's my fault, no, entirely my fault. Why can't they rely on the interpretation, either the Parry-Jones or its interpretation?
Well, they can, but
so that's a statutory override.
Well, the Lord, they can rely on it. They can rely on Morgan Grenfell, but that would be the end of the case against the FRC.
No, I'm saying either. It's either Parry-Jones,
yes,
or. I mean, because what Lord Hoffman says is obiter.
Yes.
So they can either rely upon Parry-Jones, or on Hoffman's interpretation on the basis that I've indicated that it's that his analysis is still on the basis of expressed or by necessary implication.
I accept that they can rely on that route, of course, my lord. But if they can rely on that route, then the FRC can rely.
Why? Just because one statute is interpreted as meaning something doesn't mean that a completely different statute is also interpreted as meaning the same thing.
I mean, here you've got an express provision relating to the preservation of LPP. It's quite different from the Law Society one.
I mean, don't you just say,
I'm running
in
to a head
relation to solicitors, because practically everything in their office is covered by their client's LPP, you have to imply an override in order for the Law Society to do its job. That's not the case with a different regulator, where its targets are accountants who don't hold much privileged information from their clients.
Could I attempt to deal with that point? It is it is obvious that the regulator for whom the most problems would be caused would be the SRA if there were no implied statutory override. Now, we haven't descended to the niceties of how it's overridden, but we observe that the provisions which are in SACCAR, just as a matter of statutory interpretation for a moment, the provisions in SACCAR give similar powers to the FRC as are given to the SRA. And there's a similar saving provision for privilege in the Act, and I'll give you the updated Act later, as there is in 1.8 of Schedule 2. So the question then comes down to, if we are in the reasonableness territory, is it reasonable, does the FRC reach the reasonableness threshold for that? And we say that it does, because I need to articulate, as I haven't so far, why it is difficult for the FRC to do its job without being able to see client privilege documents. And that's the gap in the jigsaw, I think, at the moment, that I haven't yet got to, but I do need to explain. Now, put simply, auditors are often shown client privilege documents in carrying out their audit. They're shown that under a waiver. And Mr Justice Arnold held that waiver didn't extend to the FRC, and we didn't appeal that. Now, I'll take that as my first step in the argument. Now, if it is necessary in some cases for the auditors to see privileged documents in carrying out the audit, then we say that in considering whether the audit was properly performed, it is obviously necessary for the FRC to be able to see the same documents, falling into two categories really. Either documents that they were shown, or documents which it might be said they should have asked for. A sort of constructive knowledge point, and you'll recall that in auditors' negligence cases it's often said, well, they should have asked for this, they should have asked for that, and likewise in the regulatory context, if you don't ask for a relevant document, then you could be in breach of a relevant requirement. So there are many possible examples, but let's take related parties as one. And I'm going to use a hypothetical example unrelated to this case. Let's say in a hypothetical case, Company A has advice from its solicitors as to whether it is in fact a related party to Company B. And let's say that advice is shown by the company to the auditor in the course of the audit. So it's in play. Now, that advice, as part of the auditor considering the related parties issue. Now, that advice is clearly relevant in considering whether the auditor was in breach of a relevant requirement in signing off the accounts as showing a true and fair view without showing the party as a related party. And so I'll give one more example, but there could be very many. But what we say is that the regulator, the FRC, in a context in which auditors are shown privileged documents as part of their audit, or there are privileged documents which they should have got hold of, which would have undermined their view, their signing off of the accounts, it is vital that the FRC should be able to see those documents in assessing the competence of the auditor, whether they have met relevant requirements.
What power does the auditor have to require the client to produce documents subject to LPP?
It doesn't, my lord. What it can say...
So, all right, so in a case in which the FRC says the auditors should have called for this document but didn't, the auditors say, well, we couldn't have because it's LPP protected, you still say the FRC can see it.
Well, there are two answers to that, my lord. First of all, it's possible that the company would confirm that it would have given a waiver in those circumstances. But that example isn't going to be the important one, because ex hypothesi in that circumstance, then you're probably going to waiver from the company anyway, so you're not going to be in the position of that we're in, where Sports Direct has not waived. So the more important example, so I see I put that too quickly. One route would be for the FRC to say, well, if you had asked, the company would have waived privilege. And you'd have got it, and you have fallen short of a relevant requirement in not asking for it. But in that example, that example is very unlikely to arise, because the company is very unlikely to say, well, we would have waived privilege if we'd been asked then, but we're not waiving now for you to look at the auditors. So that is a very narrow...
What if the company says he wouldn't have shown? He
Well,
had something to hide from the auditors.
Well, then the auditor will have will be judged according to what they got, because
Well, I follow, but your anterior point is that the FRC is entitled to see the document.
yes, my lord, and so you don't get into even asking the company whether they would have given a waiver, unless you're in a position where you you need to see that document in order to judge whether the auditor has done their job properly. Now, if the answer is, I didn't ask for the document because I know the company wouldn't have waived, then the FRC can go to the company and say, well, would you have waived? And if they then get the document, that's fine, and the auditor can be dealt with accordingly. But if the company say, no, we wouldn't have waived, then they're not relevant to the investigation. And in that case, you're not going to need those privileged documents, because you know that in those circumstances, the company wouldn't have waived its privilege, and the auditor has to be judged by what they actually had. But the auditor does have a power, and the power is to say that they cannot sign the accounts as giving a true and fair view. And that is the stick that they have. And they can therefore say, if we do not see these documents, which we know to exist, or unless you can say, well, we have given you all privileged documents in relation to this, we will not sign off the accounts as giving a true and fair view. So they don't have a power to require them to give privileged documents, but they have a very important power, which means that, well, they don't usually need the stick, my lord. Normally it's just given to them. And normally companies will...
Really, it's proper for an auditor to threaten not to sign the accounts as giving a true and fair view in order to pressure the client to hand over privileged documents.
I'm sorry, my lady. I perhaps went too far by using the word stick. I wondered at the time whether I should have used it. But what we say is this: anything can be construed as a threat, but it is certainly if as a matter of professional propriety, an auditor cannot sign the accounts as giving a true and fair view, it will write a letter to the company saying we cannot do this unless we see these documents. And that's not a threat. It may be more in sorrow than in anger, but the fact is that is the unfortunate position they'll have to find themselves in. And so they do have a route to get privileged documents, and indeed they are often shown privileged documents. Now, the anomaly in this case is that there are privileged documents. We don't really know much about them. There was a particular document in the Deloitte material, which is dealt with now, which was said to have been shown to the auditor, and that was advice from Deloitte in relation to the related party issue. Now, the FRC needed that document, and it sought to identify which it was. And the response of the company is, well, we don't know which was shown because we've identified a pool of documents, but we can't tell you which, so it doesn't meet your notice, so that's tough. Now, Mr Justice Arnold said, no, you've got to produce them. And it's quite clear why this is a perfect example of how it may be relevant. Advice given in relation to this very issue, which is said to be privileged, which is said to have come ultimately from Deloitte, but to have been covered by, I think, the communication exception. But by whatever route, the FRC, in order properly to and fairly to regulate the auditor, needs to see that. And so Mr Justice Arnold ordered that, and not only properly and fairly for the FRC, but properly and fairly for the auditor. Because if that advice said something which was material to the fact that it wouldn't be a related party, then GT would have a defence to any breach of a relevant requirement. But SDI said no, they wouldn't produce these documents. They've now been ordered to, and subsequent to the hearing, which was turned initially on a fax, which was said to be covered by legal advice privilege and litigation privilege. Ultimately, that fell away. Then, a few days before the hearing before Mr Justice Arnold, the additional documents came into play, but the Deloitte material was still in play. After the hearing, SDI served a statement saying there were only 3 documents in the pool, of which 2 were identical. They refused to tell the FRC how many documents there were in the pool before Mr Justice Arnold. And so they say there are 2 in the pool. And at that point, my lords, they then claim litigation privilege over those documents. So we're talking about a document which we have had an immense amount of trouble getting, and which we are still having trouble getting because there will be a further hearing on litigation privilege in relation to that document, those documents, unless we have, the FRC has the power pursuant to whatever it may be to get hold of these documents. So I just want to deal very clearly with the amount of difficulty that is caused to the FRC and is being caused in this case by not being able to get hold of privileged documents.
Thank you.
Now, I'll turn now to the further arguments put by Sports Direct against the Morgan Grenfell exceptions.
Do you want to deal with Sims?
My Lord,
It's only because you mentioned it. You don't have to.
indeed, my Lord, your Lordship has spotted that above that section of my notes is the Sims case, so I'm very grateful. Could we turn to Authorities 227? My Lords, in brief, the background to this was that the Law Society had intervened in the practice. They had obtained hundreds of files, and on the basis of the files obtained, client files, so client LPP files, on the basis of those files, they had brought disciplinary proceedings against Mr Sims. And the point at which we can pick it up is at paragraph 36. Now, the LPP point is dealt with there, and I'll start at what happened was that shortly before the hearing, it would obviously scupper the prosecution if they couldn't refer to client files, and a a lot of fraud was alleged. Indeed, a separate issue here was the fraud exception, which we need to deal with. So there was a late attempt to stop the files being used because of B and Auckland. And so paragraph 37, counsel of the appellant informed the tribunal the claim is being advanced at a late stage because the law had been changed by B. So that's the same argument really as Sports Direct have been advancing.
So this is a case in which the Law Society had intervened
Yes,
in the practice, so it had got the files.
yes it had.
It's trying to get them.
No, it's got them.
It's got them.
It's
and
got
it
them.
wants to adduce them in evidence before the disciplinary tribunal.
Yes it does. And it's got them, we say, pursuant to its Morgan Grenfell powers. I'll call them Morgan
It's
Grenfell
got
powers.
them pursuant to its intervention powers.
It's got them, but its intervention powers would be subject to LPP unless the LPP somehow were got around. I don't want to use that phrase actually, it'd be used against me. But unless there is a no infringement or only a technical breach, then the Law Society would have to go into a practice and say, well, we can't open the files.
Can we put it in a neutral way? They got them pursuant to some statutory provision.
They did. They did. And they're using them subject to statutory pursuant to statutory provisions.
The intervention is different. I mean, if the Law Society intervenes in a solicitor's practice, there may be many ongoing transactions, all sorts of conveyancing transactions, for instance, which need to be progressed to a conclusion.
Of course, my lord.
So one might then say, well, it is a necessary indication that the
no
Law
more.
Society can arrange for those transactions to proceed.
Well, what happens then, my lord, is that the SRA gives out files to other firms who are then instructed by the client, and if they're instructed by the client, then obviously they're part of the circle. But once you get the crucial part about, so intervention per se, getting the files, handing them out without looking to them, isn't a problem. What the problem comes for the Law Society when they want to prosecute the solicitor, as they do here, on the basis of fraud, alleged fraud. And so they have hundreds of files, and they can't use them unless the Morgan Grenfell exceptions apply. And what they were going to, and just before the hearing, the solicitor says you can't because of B. And so that's 37. 38, the divisional court say, if correct, this contention would have far-reaching consequences for the Law Society when exercising its powers of intervention under the Solicitors Act, and of course, my lord, also when prosecuting solicitors. Further, it would mean the decision of the Court of Appeal in Parry Jones was no longer good law. Yet further, it would mean that the Board of the Privy Council in the New Zealand case had disagreed with the judgment of the House of Lords in Morgan Grenfell. This court is bound by the decision in Parry Jones, and the suggestion it should be regarded as having been overruled despite its boldness, and as we have concluded being obviously wrong, needs little attention. Now, my lords, it appears to be the case that the divisional court are proceeding on the same basis, forgivably, because of the way the judgments, the speeches are in B, that client LPP is an issue in B in Auckland. So the route they find is distinguishing the New Zealand statutory regime and in essence following Morgan Grenfell and Parry Jones as saying they can survive together. But they thought they had more of a problem than they did in our submission. So at 39, they say the Privy Council concluded in the New Zealand case that the Law Practitioners Act in New Zealand did not expressly or by necessary implication override LPP, and that's right insofar as it's the LPP of the firm, and that wouldn't have affected anything. But it's clear that the divisional court think that it covers client LPP as well. And
Where were you just reading from?
I was reading from 39, my lord.
Oh, yes, I see. Thank you.
And so the way the divisional court deal with it is say the judgment contains invaluable guidance and illumination on the character of LPP, but it can only be treated as an authority in connection with the New Zealand legislation or identical legislation elsewhere. The Solicitors Act 1974 is not identical. Indeed, it contains significantly different provisions to which we will come. And then at 40, we're not to be taken as underestimating the illumination given to the law in connection with LPP by recent decisions, but we're entirely satisfied, like the tribunal in the instant case, this appeal falls to be determined by considering two issues. First, whether Parry Jones is still good law, and second, the fraud exception we don't need to trouble with. As to the first, the arguments draw attention to the speech of Lord Hoffman in Morgan Grenfell and the observation he there makes as to the rationale of Parry Jones' decision. But since the arguments also focused upon the New Zealand case, our starting point must be the statutory scheme under the Solicitors Act. And, my lords, because what they're concerned to do here is distinguish the New Zealand regime from the Solicitors Act, because they think they need to, because they have read paragraph 12 of B as meaning that it was about client LPP. We don't, unless your lordships would like me to take you to it, need to go into the distinctions between the statutory regimes. We can move to the conclusion in relation to the Morgan Grenfell point. So picking up at 48, in our judgment, the New Zealand case didn't change the law in England and Wales. Apart from the distinctions which we've drawn between the two schemes, the case of Parry Jones was cited in argument before the Board of the Privy Council. My lords, that's right, and it was cited in argument in relation to a full Morgan Grenfell override point. It was prayed in aid because of that point. As we've already observed, the Board of the Privy Council decided the legislation in New Zealand did not override LPP. Further, Lord Hobhouse and Lord Scott were members of the board in the New Zealand case. So they're using it as a reverse implication from the way that my friend, Mr Lissack, wanted to use it. So they can't have changed the law because they were all on the panel and they can't have repented so quickly. Of course, that's now not an issue once one understands the basis of it. So, 49. Contrary to the appellant's submission to the tribunal in this court, Parry Jones was not overruled by the House of Lords. Lord Hoffman, in Morgan Grenfell that is, Lord Hoffman stated the opposite. We've dealt with that passage. The tribunal in this case was significantly influenced by the speech of Lord Hoffman. It gave careful consideration to the statutory scheme and concluded, 1, that LPP had not been lost by express words or necessary implication. In other words, there was no full Morgan Grenfell override, consistent with the reasoning in Morgan Grenfell. 2, following Lord Hoffman, concluded that if the disclosure of the documents not to be used against the client or to his prejudice, and if steps can be taken to preserve the confidentiality of the document, then it's proper to allow disclosure to the tribunal. It's unnecessary for us to consider whether or not Lord Hoffman's conclusion the Law Society was authorised by statutory powers should be taken as a conclusion that LPP had been lost by express words or necessary implication, and that as a result the tribunal erred in its conclusion. My lords, we say obviously that had they considered that point, they would have concluded that it was not because of the reasoning of Lord Hoffman himself in Morgan Grenfell. He makes that clear. So they say because, they don't need to consider that because we're satisfied the tribunal's decision was right. Parry Jones remains good law. This court is not concerned to engage in a debate which might be said to arise in connection with the underlying rationale advanced by Lord Hoffman. Suffice it to say, Lord Hoffman stated the Law Society was authorised by its statutory powers to take possession of the documents, and as a result did not breach LPP, so they rely on the second limb.
Well, yes. One way or another, Parry Jones remains good law.
Yes, one way or another. That's exactly.
I think that's basically what they're saying.
Yes, and we say that.
And that must be right.
Yes, we say that, and we rely by analogy, and I hope I amplified sufficiently earlier in response to a question from my lady. The closer analogy than we had than I think the court perhaps believed there was between the SRA and the FRC in the necessity of seeing privileged documents. My lords,
So that was a decision of the divisional court.
it it was, and I'm not going to do a battle with my lord on precedent and what's binding and what isn't. I can see my lord Justice Lewison thinking about Lord Justice Waller turning down permission to appeal.
Well, it's not citable, right?
Well, I won't cite it, my lord. So moving on then to we've dealt at some length with technical breach and the issues surrounding that, and I want to deal with an alternative route, which by necessary implication is not intellectually respectable, according to what my lord said earlier, in relation to the non-infringement principle. But in my submission, it works as a rationale for that principle. Now, what's said, might I make one preliminary point? One of the ways that Sports Direct put that case is that, and this is a broad policy point, that if Lord Hoffman's reasoning is correct, then a lawyer will no longer be able to give his or her client the unqualified assurance that what they tell their solicitor in confidence will never be revealed. But Lord Hoffman clearly had that point well in mind in Morgan Grenfell when paragraph 30 in relation to Parry Jones, I needn't take you back to it, he said the policy of LPP requires the client should be secure in the knowledge that protected documents and information will not be disclosed at all. So he and his fellow judges clearly saw no incompatibility between the two principles, and an important point arising from that is that as Lord Hoffman in Morgan Grenfell and Lord Taylor in Derby will have had well in mind, the position is more nuanced than that. A client cannot be confident that in all circumstances his confidential communications with lawyers will remain so. Although they both made unqualified statements, both Lord Hoffman and Lord Taylor would have been aware that there are numerous circumstances in which the confidence can be broken, not least where there is a statutory override, of which there are several, including the Reaper override that we've seen in McKee case. And it is, of course, always open to Parliament to introduce further statutory overrides. And I needn't go to this, but Sankey helpfully sets out a list of examples at authorities 45, 1078A. Because I'm relying on a...
1078A.
Yes. And it's also noteworthy, we say, that Sports Direct accept as axiomatic, albeit we say by the wrong route, that the SRA, that solicitors cannot give the unqualified assurance that STI rely on. Because if they accept or propose or propound the thesis that there is a statutory override in relation to solicitors, solicitors in any event can't give that assurance. And on that basis, it is very difficult, we say, to share their apocalyptic vision of that being extended to it being necessary to tell a public interest entity that also applies if their auditor is investigated by the FRC. I want to move on to the clash that SDI say there is between the no recognisable interest point picked up in Adelsey at paragraph 57, which I needn't go to, and the proposition that there's the non-infringement principle. Now, we kept alive, although faintly, in our skeleton argument, the point that the no recognisable interest point was obiter in Taylor, in Derby, and that because it didn't need to be decided. Now, in the face of Adelsey, and paragraph 57 particularly, we're not keeping that argument alive. The law has decided, this court has decided, that the no recognisable interest point does not run. So we have to confront the question of whether the no recognisable interest point is incompatible from the no infringement point. And we say this, the no recognisable interest test envisages there coming a point at which privilege is spent. Because no, and this is the words of Lord Nichols in Derby, that because no rational person would regard him or herself as having any continuing interest in protecting it. And that spent language is picked up by Lord Carswell in McKee. I think it's around paragraph 81, but it's common language in relation to no recognisable interest. Now, if privilege is spent, then it's spent for all time and for all purposes. And it's easy to see that we say that the expiry of privilege for all time and for all purposes without the consent of the privilege holder or any statutory override is incompatible with the reasoning in Derby Magistrates, and the non-infringement principle, we say, is very different from that. What the non-infringement principle does is it accepts that the privilege subsists for all time, but states that there's no infringement of that privilege in certain very narrow specified circumstances, and those circumstances are where it's going to be considered by a regulatory body for a specified purpose. It's going to be, this is replied in relation to solicitors in Morgan Grenfell, but we say it's a general application. It's going to be kept confidential with that regulatory body.
So wait a minute, take this a bit. So you say the no recognisable interest principle says that privilege does not prevail where disclosure is to a regulator.
I'm so sorry, my lady, I may have moved too quickly. What I'm saying is it's the non-infringible. I'm drawing a distinction between the two. No recognisable interest as it's spent. Non-infringement says that there is non-infringement in certain very narrow specified circumstances where the relevant information is going to be considered, supplied to and considered by a regulatory body for a specified purpose. It's going to be kept confidential by that regulatory body, subject to law, an obligation to share it with someone else, which again one might, I say parenthetically, have a debate at that point as to whether the sharing was a problem. But
you say it's confidential subject to if there's an obligation to share it.
If there were an obligation of law to share it, I haven't thought through examples, but one can imagine information going to national security, for instance, where there would be an obligation to share it. But subject to that, and there could be a separate argument at that point about the sharing, but it would depend on the individual gateway by which it was being shared and with whom it was being shared. But broadly, subject to an obligation of confidence, subject to the general law, is the point. So, going to be considered by a regulatory body for a specified purpose, going to be kept confidential by that regulatory body, subject to law, the legal obligation to share it with someone else, and not going to be used by that. Let me just gloss that, if I may. No, that's fine. And not going to be used by that regulatory body against the person entitled to the privilege. Now, we say that...
What if it might be used by somebody else? And suppose there's a money laundering.
AML is a good example, my lord, where you had an obligation to...
And the complaint, let's suppose the complaint against the auditor, what you are investigating, is whether the auditor should have tipped off the authorities that there was suspected money laundering going on inside the company that he was auditing, you would have a similar duty, wouldn't you? To pass it on, with the consequential prosecution of the company.
My lord, one can obviously build examples in which the information could be used adverse. Subject if it's under an obligation of law, but my lord, as a public body, if a public body feels that it is obliged as a matter of law to share information, bearing in mind that that information is privileged information and that in the ordinary event it would infringe the human right of the subject to share it, then obviously that public body would come to court and ask the court whether it was acceptable to do so. Because a public body acting reasonably and rationally is not going to infringe a fundamental human right. Let us say the FRC or any regulatory body, and of course this applies equally to what has gone on under the solicitors regime for the 53 years since Parry Jones. If there is an obligation to share with a third party, or the body regards itself as under an obligation, and if that obligation would breach LPP, then it is open to that body to come to court and seek a ruling on whether it's acceptable to do that, and a responsible body would do that. So
these there are only three criteria that you mentioned, three criteria. And these three criteria are designed to fit paragraph 32 of Lord Hoffman's judgment.
they're drawn from.
Yeah, that's it.
Insofar as there's a cigarette paper between my summary and Lord Hoffman's judgment, that is what it is seeking to summarise that those are the criteria.
Thank you.
There shouldn't be a cigarette paper. Now, my lords, we say, and it rests here, that and Lord Hoffman appears to have regarded it as self-evident, and his fellow judges in Morgan Grenfell, that is very different from a spending of privilege for all time and for all purposes. It's a simple submission, it doesn't benefit from particular amplification, but that's clearly what Lord Hoffman thought, and that's what we say. My lords, subject to you wishing me to address you further on ground 1, and I've also dealt, other than the 1.8 point, with ground 3, but I'll come back to the 1.8 point. I'll move on to ground 2.
Thank you.
And the remainder of my submissions will be very considerably quicker than the first one. Ground 2 is, let's say the FRC is right about Morgan Grenfell. Even if they're right, then on the facts of this case, there's the real risk of adverse use. Hence, on the facts of this case, the documents are not disclosed or should not be disclosed. Now, the core of Sports Direct's argument on this point is that if there are ultimately adverse findings against GT and or subject B under the accountancy scheme, I'll come back to the accountancy scheme later, but I want to deal with the adverse use point compendiously. There's a real risk of harm to Sports Direct in the form of adverse publicity. Now, we accept, as we say at paragraph 45 of our skeleton argument, that it may well be more difficult for the FRC than it is for the SRA to anonymise the identity of a client when investigating and making findings against an auditor. But we don't say that it's impossible. And we also point out that an order of the court could ensure that there is no real risk that the documents would be used in a manner adverse to Sports Direct's interest. Now, the point at which Sports Direct says that it will suffer relevant harm is when any adverse finding is either against GT or subject B, based on the privileged material, is published. Obviously, if the adverse finding is not based on the privileged material, they can't complain of any relevant harm because that's going to happen anyway. But if they, at the point of publication, the harm occurs. That's the adverse use that is.
But how do they know whether it's been
I'm
based
going to come to that, my lady. So under its publication policy, which has been changed this year from 3 days to 7 days, the FRC gives a minimum of 7 days' notice to any party named or identifiable in an announcement. Thus,
7 days?
7 days, my lady.
What is published?
I'm coming to that one. The regulatory outcome, I'll take it now, along with such detail as the FRC thinks is necessary, and in some cases, for instance, where there's a settlement, then that will be published. So the agreement between the FRC and whoever it may be will be published and kept and on its website. Likewise, where there's a tribunal decision in the usual event, then that will be published. Now, and there have been cases, and there was a recent case, Tabata, where a party sought to stop publication and to have amendments made. Now, the outcome's immaterial. The point I rely on is the point of principle that can be done. So once you get notice, and any named party gets notice, then you have that opportunity to make representations to the FRC. Don't do this or do it differently. And ultimately, if your negotiations with the FRC aren't successful, you can go to court. Now, so the ultimate answer to the ultimate answer to SDI Sports Direct's point is that in an extreme event, and because of the desirability of publishing regulatory outcomes, and indeed the mandatory publishing, I'll come to this in a moment, of those outcomes, subject to anonymisation. The ultimate answer to Sports Direct's point is that in the extreme case, if this were an extreme case, then the FRC could exercise its discretion not to publish the names of any of the parties. Now, I hear the word discretion being used sotto voce to my left. I'll make good that it's a discretion that has to be exercised reasonably, and I'll make good that, subject to you wanting me to carry on now, I was going to turn to SATCAR, which is the source of the publication policy, and ultimately behind that to the EU directive. And the short point that I'm going to make, which I'll amplify very slightly after lunch, is that if publication will breach a human right, then it should not be published. So it may be right to say that they exercise a discretion at one point, but ultimately the FRC are bound by the law. And if a court were to decide, or the FRC were to decide, that if we publish, it will infringe a human right, and the fundamental human right of LPP, then it would not publish. But I'll make that good by reference to SATCAR and the directive after the short adjournment, if that's convenient.
Right, but just to summarise what you've got to so far. So you summarise what you say is STI's submissions of a real risk. You interpret that to mean, what they say, a real risk of adverse consequences on publication of findings against, for example, Grant Thornton or Subject B.
Yes.
The point there is that can be mitigated in two ways. One is 7-day notice, and the second is it may be after representations are made that the FRC itself decides not to publish, or I suppose you could then go to apply for some injunction.
Yes, and
Is that what it comes to?
Yeah, so I'd only change in that the word mitigated. It can actually be eliminated, because if ultimately the court decides the only way not to infringe the human right is for no publication of the names, then that will be the answer.
I'm sure those provisions exist. Perhaps for me, for my part, it would be enough, I think, for you to just tell us where
Certainly,
they are
Melody.
for our
So-
vote. So I don't think we need
Yes.
to go to them. unless-
No, so the point's a simple one, and even if there weren't these provisions, my lords, my lady, then the FRC can't breach human rights. So the provisions, and I need to come back to in that case, are SATCAR section 6.3, which is at authorities 1.5, page 67.
So we'll give it 6.3,
Yes,
and was bundle of authorities.
1/5,
Yes.
tab 5, page 67.
Thank you.
Just, if I may gloss this, so we'll save time after lunch. The wording of SATCAR talks about disproportionate harm to a party. And the way we construe that, subject to the directive and the general law of human rights, is disproportionate means which will infringe the human right. But that becomes clear from the directive. The directive at 1/6, tab 6, pages 107 to 8.